I've also got the very unenviable task of getting us back in on time, so I'm going to be a very strict chair. But it is a great pleasure for me to start off by introducing Naomi Hawkins, who's a senior lecturer at Exeter University and has ongoing associations with us here in Oxford, which is really nice. And she is going to talk about some empirical work she's been doing, considering the role of patents in the development and delivery of NIPT. Thanks, Naomi. Take it away.
Thanks very much, Nina, and thank you to everyone for coming back so promptly from the coffee break, which I'm quite impressed by, to be honest. So as Nina said, I'm going to present the results today of some work I'm doing looking at patents in NIPT and non-invasive prenatal testing, which I will refer to as NIPT. And I think NIPT is a really useful case study for us to think about in relation to genomic medicine and personalised medicine particularly, because it's a way that we can explore how patents might influence these fields in the future. So NIPT has been described as at the vanguard of genomic medicine, and really it's one area where genomic medicine is having more population relevance than perhaps for single gene diseases, which are on the whole rare diseases. I appreciate that many of the people in this room will never experience pregnancy, but certainly pregnancy is not a rare disease like something like cystic fibrosis, which is one of the more common genetic diseases. So prenatal testing is an example where we can look to the way patents are affecting this field. So what I'm going to do is present the results of some work where I've examined the way that patents are affecting people who work in developing and delivering these tests. And for the purposes of today's talk, I'm very much going to focus on the public sector in Europe. So as Shubhita very nicely highlighted yesterday, there are some really important differences between the US and Europe in this field. And whilst some of what I say is also applicable in the United States, I'm very much going to focus on Europe and also very much going to focus on the public sector. So just to begin, I wanted to talk a little bit about the technology. Now, a lot of people prior to me have highlighted some information about the patents in this field, which is great because I will skip over some of my slides as a result. But just to briefly explain a little bit about the technology, I'm not sure how familiar everyone is. But when I speak about non-invasive prenatal testing, I'm speaking about a type of testing technology which involves the analysis of cell-free fetal DNA from the plasma of pregnant women. At the moment, it's clinically available to screen for fetal aneuploidy. So we're talking about trisomies 21, 18, and 13, so Down syndrome and a couple of other less common trisomies. It's also at the moment offered for some sex chromosome anomalies and some microdeletions. So, for example, DiGeorge syndrome, if that means anything to anyone. In the future, it may be possible to sequence the entire fetal genome non-invasively. That has been done in a research setting, and that perhaps points to something of a brave new world. But certainly that's not something that we're looking at commercially or clinically at present. Now, you might ask, why is this important? Why would we be interested? Well, it's non-invasive prenatal testing has been something of a holy grail in medicine and in research because certainly within the Western world, there is a push for prenatal screening for many diseases and particularly focused around Down syndrome, largely because it's common and because we can. And I will leave to one side the ethical questions of what we should or shouldn't screen for in pregnancy. But the testing that is done early in pregnancy, which is non-invasive, is typically not particularly accurate, so you get high false positive rates. If you have a high risk screening result, you tend to be referred for invasive testing. Invasive testing is not risk-free. The exact percentage of risk is contested, but there's typically somewhere between a 1 to 2 or lower risk of miscarriage as a result of invasive testing. So there are risks involved with accurate testing. NIPT has an advantage because it offers a much more accurate test. It's still a screening test, it's not a diagnostic test, but there are many fewer false positive tests. So as a result, fewer women will be referred for that invasive, more risky test. And so this is why NIPT is something that researchers have been working to for a number of years. NIPT has developed rather differently to genetic testing in the single gene arena. There are a number of companies that are involved, and this slide shows just a few of the many commercial providers. You'll see some names that may be familiar to you, particularly Illumina, and Illumina is one of the big players in this field. There are 4 companies who were early market entrants, and that's Sequenome Veronata, who has subsequently been acquired by Illumina, Natera, and Ariosa, which was acquired by Roche. These tests were first commercially available in late 2011, early 2012, and since sort of late 2014, the commercial landscape has changed greatly, with a number of companies being acquired and key litigation being compromised, although not all the litigation compromised. So there's been quite a lot of talk of certainly one of the key patents and the litigation about one of the key patents by other speakers, so I'm not going to concentrate in a great deal of detail in relation to that, except to say that there are a number of key patents, patent applications in this field across the world, focused very much in the USA, Europe, and Australia, which are the 3 jurisdictions, well, calling Europe a jurisdiction is perhaps inaccurate, but the 3 areas that I've particularly focused my research. Most of these patents claim the use of cell-free fetal DNA for prenatal genetic testing, so they're very much methods patents, not your typical gene sequence patent that we were perhaps more concerned about in the past. But as a method patent, arguably, there may be more difficulties with inventing around, although that's not necessarily always the case. Almost all of the commercial NIPT providers own or control some patents. The main patent that is discussed in relation to NIPT is the 540 patent, the last 3 digits of the US patent. I refer to it as the 540 patent as shorthand, but I also mean the corresponding patents in Europe and Australia. Now, that was based on work carried out not very far from here by Dennis Lowe, assigned to ISIS, and I appreciate that the next speaker may know more detail about this. And Sequenome then acquired worldwide exclusive rights and purchased patent rights in 2014. That patent, as we've already heard, was then invalidated in the US. Litigation continues in relation to its counterparts in the UK, in Europe, and in Australia. So we are yet to know the results of the current patent fights about this particular patent. But really, this is only one patent in a greater landscape. It's only part of the story. There are many patents in this field, and they are controlled by many different parties. So when we look at this patent landscape, it certainly seems to have the hallmarks of a patent thicket with the potential for royalty stacking, very similar to the sorts of concerns we had in relation to gene sequence patents approaching 20 years ago. So what are we concerned about? Do we have the same concerns in relation to this field as we did for gene patents? And should we have the same concerns? Because these concerns in relation to gene sequence patents were largely overblown. The evidence for impact or negative impact on patient access and care really didn't materialise. So is there anything different about NIPT? If so, what is different and how should we address it? So my research came about because in the early days, it did seem different. So I began my project in 2014. It was funded in some time before that, and as a result of a few maternity leaves, my project is still continuing. So I have seen the development of the technology and the field, the market, everything has changed a great deal over this time. So the rapidly shifting patent landscape has given me a chance to consider some of these issues, and I'm going to present some of the results now. So what is the impact on in this field. So I'm going to present the results of a study, of a qualitative interview study, approximately 35 interviews with stakeholders. The people I've spoken to are patent users, not patent holders. And when I talk about patent users in this field, I am focusing, certainly for the purposes of what I'm discussing today, the people who are involved in developing and delivering these tests in Europe. Now, primarily, this is people who are working in public sector laboratories. Genomic medicine and genetic medicine in Europe has primarily been delivered through the public sector. And certainly within the near future, we would expect that this test will have a great public sector involvement. There are a few reasons for that. Certainly, historically, genomic medicine has been delivered through the public sector, and all our systems within Europe are set up in that way. So these new tests will probably plug into that same system. Also, there's a great drive within Europe for NIPT to be delivered through existing and appropriate prenatal care pathways. And typically this will be through public sector prenatal care, which will involve obstetric care as well. And that's partly to do with the logistics of delivering the test, but also for reasons of justice, equity, and ensuring appropriate prenatal care. Doctors are most concerned that women don't go off and have a private test, get a high-risk result, and not have access to appropriate counselling and care. So within Europe, we would expect that the public sector will have that involvement in this test. I would caveat that issues in the States are slightly different, although similar concerns arise. It's just it's approached in a different way within that healthcare system. So that's my reason for focusing very much on the public sector here. In terms of the results, I'm going to speak about them under this framework of analysis. And I draw here as well on some work I did in the past on single gene testing. Now, I'm aware that John is going to speak very much about gene patents fairly shortly, so I hope that what we're saying is fairly consistent. So when I speak about these issues, I'm going to draw on work I did on single gene testing as a comparator. So when I speak about this, I talk about awareness of the legal framework. How aware are those who are developing and delivering tests of patent law, the obligations of patent law, what patents cover, and how it might affect their work? So that's what I term general awareness. Specific awareness, I talk about specific patents, whether these people carry out due diligence searches, whether they're interested in freedom to operate. So in terms of awareness, in relation to single gene testing, the work I did some time ago now found a very low level of both general and specific awareness, certainly in the NHS. So there was a lot of what I've termed willful blindness. Within the NHS, those working on developing testing tended to say, well, yes, I know there are patents, but if I just ignore them, they probably will either go away or it won't become an issue for me. And on the whole, that was a fairly reasonable strategy, it proved in the longer term. In terms of NIPT, on the other hand, the level of awareness, I would suggest, is different. There is a much greater general awareness of the need to be cognizant of patents, but perhaps more interestingly, people I've spoken to are very aware of the ongoing litigation and the patents held by Illumina. And they are more likely to carry out due diligence than in relation to single gene testing. Due diligence or freedom to operate searches were virtually unheard of by anyone in the public sector in Europe in relation to the development of single gene testing in the public sector, certainly. But that is very much not the case in relation to NIPT. So I have a number of quotes that illustrate this quite nicely. And this interviewee said, it's almost impossible not to be aware of this. So I thought that was quite illustrative. I asked this person when they started to consider the IP, and he or she said right from the beginning, this is a subject that as soon as you start talking about NIPT, then people start talking about intellectual property. He or she then goes on to say, but we were never approached by the companies, which is an interesting contrast. So even though he's thinking about it, he's never been approached. that is perhaps slightly unusual in terms of the interviews, because although he was never approached, most of my interviewees have had those discussions. So this person was aware of it internationally from the moment the company started to fight. And this person talks about how patents are a bit of a minefield, but hasn't recently looked into who has come out as being top dog, which I thought was an interesting way of describing who wins the argument. So, as I said, in contrast to single gene studies, people do report engaging in some due diligence, and particularly in seeking professional advice. I haven't included quotes about that because they tend to be quite identifiable, so that's slightly problematic. And a number of my interviewees mentioned concerns about their freedom to operate as a reason for taking certain action and certain decisions in relation to testing. So, for example, one lab stopped offering a test because of concerns about freedom to operate, and that is not something that was commonly the case in relation to single gene testing, although there are isolated situations and isolated cases, certainly not for such broad population relevance testing. Others have discussed concerns about freedom to operate as reasons to consider partnering with the patent holder, reasons to license a particular type of test rather than a competitor, or reasons to avoid working with certain partners as opposed to others. So those issues are interesting. Also, I said I'd speak in terms of a framework of awareness and costs and benefits of compliance. What I found in the work I did in the past was that parties would carry out a balancing exercise, which was more or less sophisticated in some cases than others, where they balance the risks or the costs and benefits of compliance as opposed to non-compliance. So whether they would carry out freedom to operate searching, whether they would engage in negotiation and licensing. And this is also evident in the case of NIPT, but the considerations are different, and the weight placed on certain considerations is different, and also the direction where the balance is seen to lie is different. And I want to focus on two areas here. First is in relation to litigation and the risk of being sued, which obviously points one way, and royalties, which points the other. So firstly, in relation to the risk of being sued, in NIPT, the risk of being sued is perceived to be high. And as I said, I've carried out this study over some years, and this has changed over the course of the study. So early on, when the litigation was primarily in the United States, and it was very early days for litigation in Europe, some, not all, but some interviewees were much more laid back and were sort of spoke about the Myriad case and the contrast between the US approach and the European approach, and sort of discussed how, well, gene patents went away and maybe NIPT patents won't be an issue either. But that has markedly changed over the course of the study as the litigation has begun to proceed in England and Wales and in parts of Europe, and an injunction was granted against an NIPT provider in Germany. So litigation is in progress and cases have been decided, and as well there are increasingly active enforcement actions on the part of the patent holder. Perhaps what is relevant here is that every lab, or virtually every lab, and probably every lab, has contact with the patent holder because they are the market-leading sequencing company. So they already license, they already purchase products, machines, reagents from this company. So, and the company has a very good idea of exactly what testing they're carrying out, and will know probably down to the numbers of tests that they carry out because they supply their reagents. So you can't fly under the radar. You have to have that face-to-face meeting, phone call, email contact with the patent holder, and that patent holder can raise these issues. And all these labs are aware that this is happening. They're a very close network. They speak to other labs who are in the process of conducting these negotiations. So that question of litigation and enforcement is high. as well on their agenda. So this interviewee talks about being well aware that Illumina is suing a number of people, is aware of the litigation in the United States, and we have concerns that they will approach us. This is in relation to royalties, so I'll go back. However, so whilst the risk of being sued is high, at the same time, there are other reasons that labs might not want to develop their own test. And those reasons may not necessarily be that closely related to the patents. So there are many good reasons why labs might wish to send their samples out. They might wish to license the technology in, to do with the volume of testing, it not being worthwhile setting up their own test in-house, the quality of testing perceived to be higher with the external provider, lots of other features. It just so happens that the intellectual property licensing tends to point the same way. So what you can see when from the interview data is that all of these factors tend to be tied in with discussions of IP. But in contrast to the single gene work, where all of the concerns were against licensing or against compliance broadly, here they point in the same direction. The second area I wanted to focus on in terms of the balance is in relation to the cost of licensing and the cost of royalties. So this is the main area that's flagged up as a downside to compliance. And this interviewee talks about, well, I don't object to paying a reasonable amount, which he or she terms as €1 or €2, and I think that is obviously slightly optimistic. And I think he's well aware of that. The current royalty demanded is $75 US. I understand it's £50 in the UK, which I'm not sure how they've negotiated the changes in currency rates, but it's not going to help. And certainly this was a non-negotiable royalty rate for some time. However, most recently, I've been told that there is now some move to renegotiate the rate. So whether or not that will change, and whether or not that might be motivated by upcoming litigation and upcoming patent expiry, we can only speculate. So this question of the amount of the royalty is very key, and in relation to some tests, that fee is seen to be entirely unrealistic and will be a block. So in this quote, this is a lab director who's deciding whether or not they can continue to offer a test because of the royalty. And so she says that it's obviously with the management team. We have to take a view on, do we just pay the fee? It's very tightly costed. We'd make a loss on every single sample. And the reality is, for this particular lab, if they paid that royalty rate, then other testing would have to subsidise this test. And ultimately, they did stop offering the test because it wasn't financially viable. That said, testing was still available in other labs, but if you happened to live as an NHS patient within that area, then your options were to either pay for your testing privately or not have it done. And that is quite a change on the whole to most single gene testing. So I entitled the presentation, Is There Cause for Concern? And I'm not quite sure how to come to a conclusion and to answer that. And perhaps the answer is a typical lawyer's answer, and to say maybe, which isn't very helpful, I guess. But what I would say is, if our primary concern is patient access to appropriate diagnostics and appropriate medical care, then perhaps we needn't be terribly concerned. So again, like with single gene testing, if our concern is patent thickets and royalty stacking and all of those sorts of things, I think the concern is overblown. There's very little evidence that these things block testing, because we have a marketplace with huge numbers of companies, not only the 4 big ones, but we have a UK-based company that is hopefully going to continue to offer testing after some litigation. There are companies in other jurisdictions. But in terms of public sector testing, maybe things will work out differently. And royalties is obviously a key question, although presumably that can be negotiated and sorted out. And a great deal will depend on the bargaining power and the negotiating power of public sector governments and commissioners within the NHS. So we don't have a monopoly situation. Access might be a problem, but that will be dependent on cost. So overall, perhaps not a huge cause for concern, but there are still some residual issues that we will need to see how things resolve in the future. And perhaps competition law and concerns about the way some of these major companies are exercising market power and leveraging patents in different fields is an area that we could look at in the future. But thank you.